Hello, everyone, and welcome to Uncivil Law. For today's case, we have someone suing the state of Illinois dealing with marriage laws because they feel like they're not quite as expressive as he would like for some interesting reasons, perhaps. This is a story of Kenneth Mail versus the state of Illinois. In this case, Kenneth over here has some religious objections to the marriage laws of Illinois. What exactly are those objections? Well, we're going to find out. Let's get started with this. For the second time, Kenneth Mail has sued the state of Illinois to challenge state laws prohibiting bigamy, adultery, and fornication. The district court dismissed this second suit, in part on issue preclusion and for part of lack of standing. We affirm. Mail is a self-proclaimed Satanist. He says he follows the law of Thelma, a set of beliefs developed in the early 1900s by Aleister Crowley. As part of this religion, Mal participates in what he calls sex magic rituals that he believes violates Illinois' laws forbidding adultery and fornication. Mal says he reasonably fears prosecution for practicing his beliefs. He also says he wants to marry more than one person at the same time, and that if he were to do so, he would violate Illinois' law against bigamy. Okay, so Mr. Mail over here apparently has a rich and lucid sexual life or something. So he's a Satanist, and he'd like to engage in behavior that is technically prohibited by law. Not that anyone really cares that much, since various things, although the marrying multiple people thing a little bit more. He thinks that he has some religious objections to this, and he'd like to marry more person and engage in his behavior with his partners, which I'm sure must be very interesting, I'm sure, but okay, that's what Mr. Mail wants. In 2017, Mail filed the first of his challenge to those laws seeking declaration and injunctive relief under the First and 14th Amendments. Freedom of religion, great. The district court, in that case, granted the defendant's motion to dismiss under federal rules of civil procedure for failure to state a claim. You don't say. The court ruled that the bigamy claim was barred by Supreme Court precedent upholding the constitutionality of anti-bigamy laws. The court then dismissed for lack of standing the challenges to the adultery and fornication statutes because he could not show a reasonable fear of prosecution, so he lacked standing to sue. So, like many states, there are technically adultery laws and fornication laws on the books in many states. Those have been rendered largely inactive by many, many court decisions, but they are still technically on the books, maybe as a virtue or whatever. But, you have to show some reasonable probability of being criminally charged. You don't necessarily have to wait till you are charged, but you have to show some reasonable probability. And Illinois, I'm just going to go out on a limb and say that they haven't prosecuted anyone for adultery or fornication in quite a long time. There's really no threat to you. So, you do you. It's fine. As to the merits of this thing, we need to look into it, we can fortunately be brief. The district court's reasoning was in fact sound. The court correctly dismissed the challenge to the bigamy law on preclusion grounds, already having rejected a nearly identical challenge in his earlier federal suit. So this is not his first rodeo. He apparently is really unhappy at the bigamy suit. And so he has sued the state of Illinois more than one time on the same issue. Now, every lawyer in the room knows that there's things called res judicata. Res judicata, it is issue preclusion. There has been a thing decided, and it's the same exact issue with the same exact parties. And so we're not going to hear it twice, not that we were particularly persuaded the first time. So, no. Issue preclusion ordinarily bars relitigation on a fact or law raised and necessarily resolved in a prior case because that would be inefficient. Here, the parties and issues in the bigamy challenge were in fact identical. Likewise, the court correctly dismisses the challenges to the adultery and fornication laws for lack of standing. Those laws are no longer enforced, so you can't show a reasonable fear of prosecution. Right. Adultery and fornication laws remain on the statute books, archaic and unenforced, a residue of legislative inertia, or maybe because they want to represent virtue or something, whatever. Nothing relevant has changed on that front since the 2017 dismissal. Therefore, the judgment of the district court, because this guy appealed for some reason, is affirmed. Thus, that brings us to the end of our discussion of Kenneth Mail and state of Illinois. My most operative question here is, how is Kenneth Mail getting multiple women apparently wanting to marry him? This is the really burning question in my mind. What is Kenneth Mail offering that multiple women apparently are totally cool with him? And he says, I'd like to commit adultery and bigamy. And these women say, I definitely want a piece of that Kenneth Mail lifestyle. What is he doing that is working for him? That is the real question in my life. But putting that aside, let's deal with the legal issues. Yeah, the Supreme Court has said that bigamy is illegal long ago. And so, no, not so much. And as to your other ones, you have no fear of prosecution like ever because no one's being prosecuted. I don't know why you sued twice. I don't know why you brought this to appeal. I don't know why you thought anyone would care. But, go live your life. Do your fornication, adultery, bigamy, whatever thing. Just stop asking the court. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.